Now, a will versus a deed of gift. So a person could will a property to his wife, for example, or they could do a deed of gift to the wife. Now, a deed of gift is an irrevocable trust, which simply means that once you do that, I will answer the question that was just posted. Once you do a deed of gift, you cannot take it back. Versus a will, you could change a will every Monday morning. If you get up on Monday and somebody get you on your bad side, you could just change your will. However, a deed of gift is an irrevocable trust. You cannot give it back. Now, sometimes a lot of parents go ahead and want to give to avoid the hassle of probate. They may want to just give the property to their children. For example, I always advise my clients, there's not a problem with doing that. You love your children, but reserve your life interest in the property. So therefore, they can't put you out when you give them and you can't take it back. You know, sometimes you have a disagreement and the children end up putting you out your house. So you reserve life interest in the property, which means therefore that you own the property, and only upon your demise then the property passes to whoever you would have gifted it to. In terms, well, this is, although a will and a deed of gift conveys property, or the will gives property or bet to the beneficiary, and a deed of gift essentially does the same thing. There is a cost factor, because with a will, the cost will only arise upon the person's death, where they have to probate, and even after you probate, you still have to do a deed of assent, versus a deed of gift that has to be stamp dutied, that has to be valued before it is registered. So that is something that persons may want to weigh up before they make such a decision. Before I move on to a deed of assignment, I'm not sure if Ms. Joseph wants to take that one. But before we go on to that, I would like to answer some of the questions that have popped up since speaking.
Yeah, so I would suggest you proceed to answer what came up right away, and then we can
get lost.
It starts with DI. My both attorneys.
Right.
The first question.
So DI, my both attorneys have said that the will has to be registered. That is incorrect. As I said, a will does not have to be registered to be valid.
In the first place, I think you corrected yourself earlier when you said it's not registered in any event. It is lodged.
Yes.
It's not a registration exercise.
Right. It's a deposit. Yes. It's you deposit it, you lodge it. Yes, I would have corrected that, right?
Right, you did.
So I'm not sure why, if that is what your attorney is suggesting,
it is wrong.
He knows the circumstances. I'm not sure if there's
certain circumstances. The person may have said that in order for you to protect yourself from the persons who have an interest in your property, or the fact that because as I have a situation now, the lady did her will and took it home and put it in a safe place, and her son knew where that place was. But on her death, the daughter went into the lady's room and took away certain documents, and she is now saying that the mother did not leave a will. So I am agreeing with Ms. Sobers in a situation where the attorney may be aware of these kinds of possibilities. The attorney may have suggested that the will should be lodged, deposited. It's not registered. It is deposited at the Hall of Justice, Probate Division, for safekeeping.
Yes. So, Listra, I believe that would answer your question as well. Can wills be registered in Tobago at the Registrar General? It must be registered, not registered, lodged or deposited at the Probate Registry, Knox Street, Port of Spain. Right? Wade Kanhai.
No, I think no, there's Miss Danielle. Today we look forward to come right.
Yes. So it's Wade Kanhai.
Yes.
Is it a must to have an executor or executrix with a will prepared by an attorney at law? I'm not sure your question, but yes, you should have an executor executrix. It can be a beneficiary, so they can be the same persons to do it. A will does not have to be prepared by an attorney at law. However, as I would have said in the introduction, because it can become technical, it would be preferred to have an attorney at law that is competent in this area of the law, to just ensure that all the technicalities, all the legal prerequisites are met.
Agreed. And you don't have to have one executor and one executrix. The law allows you to have as many as 4 persons as executors of your will. I see Gail Alexander Walters. For my privacy, because of the nature of the question, kindly refrain. Oh dear me. Okay. The other, all right, heard. All right, but we'll see. Dwight. So let's go to Dwight. To continue from what Ms. Sobers was saying, if someone dies intestate, what happens to the estate? If the person had 1 child. So I'll hand it over to Ms. Sobers. You want to answer?
Which one is that?
Well, I don't think Dwight said not to call his name, so we can go ahead.
To continue from what Mr. was saying, if someone dies intestate, which is without a will, what happens to the estate if the person had 1 child? Okay, so the Administration of Estate Act will come into play, Dwight. So the first person legally entitled to make that application, and it's not for probate anymore, it will be a letters of administration, would be the spouse of the person or the legal spouse. There are circumstances where somebody says, well, it's my common law husband. There's another application that needs to come before that, which is application for a declaration that this person is the common law spouse of the person. After that, it would be the child that you mentioned. You said they had 1 child. That child would be entitled to make the application for letters of administration.
Provided the child is an adult.
Yes, provided the child is an adult.
But we sort of kind of covered that last week, and some persons may not have been here last week, so not a big thing if we have to go over 1 or 2 things. Farida, how can I give my children my property without them having to probate? Oh, well, that takes us nicely into what Ms. Sobers has spoken about earlier, deed of gift. So I don't know, Ms. Sobers, you want to repeat?
Right, this is to Ms. Farida, right? So you can do a deed of gift, Farida, and what I often, as I keep repeating that, what I often suggest to my client is to retain life interest in the property, which means you still own the property, and only when you die, then the property will pass automatically to your children. You would not have to probate, you would not have to do any subsequent deeds for them to have it in their possession, right?
All right. Okay, so you want to go to, all right, we were next to go to deed of assignment because we've just covered will versus deed of gift versus deed of assignment. So I can just quickly talk about deed of assignment, then we can come back to some questions. The deed of assignment is a completely different ball game, for want of a better word. The deed of assignment is where somebody has a leasehold interest in land versus a freehold. Very quickly, if you hold land as a freehold person, it means that you have a right in perpetuity, even after you die, because you own the estate, the entirety. That's a freehold. As opposed to leasehold, as the term lease implies, it is for a specific period of time. So once property is moving from one person to the next, and it is leasehold land, it is called a deed of assignment because you are assigning the remainder of the lease. Generally, people will hold property like in Woodbrook for 30 years. And you can assign, let's say you have 25 more years on the lease, you are assigning that length of time, as opposed to freehold property where you would do a deed of conveyance. So it's only because it's freehold versus leasehold, Leasehold, we say you are doing a deed of assignment because you can only assign the length of years that you have. Freehold, we say deed of conveyance. In both instances, is the transference of ownership from one person to another. I think that should cover deed of assignment.
Yes.
All right. So you
now,
want to go ahead.
A deed of assignments, although it may seem it may be a new word or phrase that we're learning about, it is actually pretty popular because all HGC buildings or homes are by way, at least most of,
yes,
not all, but
yes,
most of,
yes,
are by way of deeds of assignments, right? Now, with deed of assignments, the process, although simple in terms of the conveyance from one to the next, especially for HGC, it was a requirement as of March 2022 to get the consent from HGC, which is in a particular format. And there are several documents that you would have to provide to HGC before you get such a consent. So that's something that you want to keep in mind, audience, as well. If you are considering doing a deed of assignment, you can't just say, here, what I'm going to assign it to Tom, Dick, and Harry. There are certain legal requirements from or policy provisions by HGC that you must adhere to in order to get that consent as well. Now, a deed of lease, when people hear leasehold property, they sometimes feel turned off, but a deed of lease can be a life lease. It could be for 999 years, which I have seen quite a bit. So it's not unusual. One moment. It's not unusual to see these kinds of instruments. In fact, West Shore, not West Shore, yes, down that side.
Yes, down there, that area.
Yeah. Most of the property there is leasehold property.
Yeah, because all of that property is owned by the Port of Spain Corporation. All of area Peter Avenue, you are absolutely correct. Yes. Because I worked at the Port of Spain Corporation, all of our Peter Avenue, all of the streets, side streets, 𝗵𝗲𝗪, Lewis, what have you, all the streets there, all of that is lands. Those are lands owned by the Port of Spain Corporation, and every householder there has a lease. Even one Woodbrook Place is also lands owned by the Port of Spain Corporation. Everybody has a lease. The main lease is held by HCL, and then the sub-lessees are all the persons who are tenants. And then Ms. Sobers is absolutely correct. Further down, Westmoreland, and some of Powder magazines, some of those areas, a good bit, and some lands in Gonzales too. They're all owned by the Port of Spain Corporation. So Ms. Sobers is absolutely correct. And then all of the HGC properties, almost all, as she has said before, leasehold.
Yes.
People with 30 years, some with more.